beginning of the year to, despite the fact that we're all sick of online webinars because of COVID and we all want to get back in person, we still think that there's some benefit to thought sharing and exchange online for particularly interesting hot topics. So just so everyone knows, we are recording this webinar for the benefit of everyone who can't join us. And the speakers are okay with that. So if anyone would be concerned about being recorded, then just keep your camera off, I guess. And for the purposes of sharing questions and asking questions, please put your question into the chat and we will try and address it as we go along, or address the questions at the end. So we only have 40 minutes because I'm aware it's like an after work type webinar without the cocktails. But maybe you all have cocktails hidden behind your cameras. So I'm going to start by introducing our fantastic speakers that we have today. We have two fine ladies from the world of arbitration and legal tech. I'll start with you, Sophie. Sophie Nappert is probably known to many of you already. She is an arbitrator in independent practice based in London. She's dual qualified in Canada and England and Wales. Before she became a full-time arbitrator, she was an advocate and head of an international arbitration in a global law firm. And she has been commended as a leading light in her field by Who's Who Legal. And I thought that was a really nice description, a leading light. Sophie is sought after in complex energy investment and natural resources disputes, and she is a pioneer of arbitration and legal tech, which is why she's with us today. And from my perspective, she's the first person that managed to explain to me many of these topics that were gobbledygook for me up until our conversation. And many of you will also know her from founding Arbitech, which has been around since, correct me, Sophie, 2021, last year. Yeah.
Yeah, it's just over a year old.
A year old. Okay, so coming up to its first birthday, I think, or yeah.
Well, just over.
Okay, just over first birthday. Very good. And in her spare time, she has many other achievements and activities, but in her spare time, I thought this was really also interesting to give back to the community. She created the Nappert Prize in International Arbitration for young scholars and practitioners in the McGill University. So giving back to the youth and encouraging the youth. And then we have another fabulous lady in arbitration, Aija Lejniece. She's also an independent counsel and arbitrator, but based in Paris. She has over a decade of experience in international law, international investment law, and commercial arbitration from Latham & Watkins and Cleary Gottlieb. She advises clients in high-stake international disputes across various jurisdictions, and particularly another reason that she's with us today in crypto. So most notably advising traders in a dispute against the world's largest cryptocurrency exchange, Binance. So that is, we're going to hear more about that now. So the topic of our webinar today is the ABC of legal tech. And the idea was came from, like I mentioned before my talk with Sophie, I felt like it might be necessary to explain the tech concepts, language and vocabulary to lawyers and kind of talk about what kind of a tech journey arbitration is embarking on, because I think maybe for some of us it could be potentially a little bit daunting as to where where this world will be taking us. So maybe we'll start off with you, Sophie, about maybe you can just tell us kind of how you got into the world of legal tech. You know, what was it that interested you or sparked your interest in legal tech, and why?
Why? Very briefly, I came at it via the portal of algorithms and artificial intelligence, because I started wondering as a decision maker what influence the machine learning and evidence produced with the help of algorithms would have on my thought process. In other words, how impressed would I be with a robot who can crunch data much, much faster than humans? So I started getting involved with this. And this is back in 2016, which obviously in legal tech terms is light years ago. And from then on, I started being interested in the, at the time, emerging power of blockchain, particularly Ethereum. And I decided to get to grips with it and to understand it properly by taking a course on blockchain strategy, which I did in 2019. And that essentially opened, I would say, my mind to the fact that this was an area where disputes occurred. It is an area where people transact. It's an area where, and we can see in the recent phenomenon of the metaverses, the numbers are extremely large, changing hands. And therefore, disputes will arise, and what does one do with those disputes, and how does one solve them? And now with the Web3 economy, we are looking at the phenomenon where the time factor of transactions is extremely different from what it is in off-chain life, in the normal life that we know. And therefore, the time factor of dispute resolution likewise will have to adapt. You cannot, absolutely cannot, have any credibly import arbitration as we practice it with its very lengthy, very time-reliant processes into an environment where what is prized is immediacy, and the fact that you just need to get rid of these disputes and carry on trading. And so that's what got me interested in this phenomenon, in this space, because it is an opportunity to wipe the slate clean and start again properly. And that's fascinating.
Absolutely. What about you, Aija?
So I got into crypto a little over a year ago in a very practical and intense manner when I just left Latham, established my own practice, and a friend of mine called me and said, "Hey, I've lost money trading on Binance, and a couple of other people lost money too. I think there's an arbitration clause. Can you take a look?" And so I was rushed into this world of traders and crypto and this whole like online platform that people live on, which ended up we ended up getting financing, and it ended up blowing up pretty big. So I obviously started, getting more interested, looking at what crypto actually meant from a practical perspective, because obviously, like, it's been years since we hear about Bitcoin and crypto and these exchange platforms, etc. But I got like a very good practical primer of what the community is like, what their priorities are. I think, as Sophie mentioned, time is of the essence. These guys want things like now, they want everything done yesterday, because the priority for everybody as a trader is to keep on trading. And then after that case started, I got involved in several other arbitrations that relate to crypto. And I think one thing about the blockchain technology and crypto is that it can be so diverse. You can have, because it's both an asset and a currency, it can be a thing depending on how you interpret what a digital asset means. And there's a lot of different issues, and I think it's going to pose a lot of challenges for the arbitration community, because we are used to, we think of ourselves as, oh, we're less formal than courts, but for us, for the community that is into blockchain and crypto, we are sort of the old guard and very formal, and everything takes a long time, and it's there's so many obstacles. So I think we as practitioners and also arbitration institutions will have to deal with that pretty soon if we want to stay.
I think actually, Sophie, you might have mentioned the dinosaur of arbitration in a talk that you gave recently when we talk about arbitration. And to be honest, what you've both said about the time factor, I mean, as an institution anyway, we love to sell arbitration about as being so efficient. And we think we're great with our fast track arbitrations, and also I think when you look at from a law firm perspective, we also think that we're super efficient and work really fast. But this is obviously a game changer, and the next level of speed and efficiency that's required. But maybe before we talk about that, so if we could take maybe a step back and talk about, like, how would you describe the basic concept of blockchain? Like how does this type of dispute resolution forum work? I know that you work with Clearos quite closely.
Yes. So very quickly, the blockchain is an online space where transactions are coded in a manner that is transparent and immutable, cannot be changed or can be changed only with the consensus of everyone that takes care of maintaining that series of transactions, these series of blocks. I'm giving a very basic, very simple explanation at this stage. It's not unhackable, and it has been hacked, but it is difficult to hack as well. So there is an element of security because of the cryptography, the keys, the puzzle solving that the coders get involved in. Now, initially, blockchain was created for Bitcoin, that everybody knows, the first widely adopted cryptocurrency. There are several blockchains. The Bitcoin blockchain is one, and it is still the main support for Bitcoin trading. There are other very well-known blockchains. Ethereum, that I mentioned a little bit earlier, is another one that was that is second to the Bitcoin blockchain in market capitalization. And it has been created by a Canadian, actually, Vitalik Buterin, who essentially wanted to have something that was not limited to crypto, but could accommodate as well decentralized finance systems, and also, for our purposes, decentralized justice, as it's come to be known, which is blockchain, in shorthand, blockchain arbitration. Right. Kleros, which you can look at their website, is kleros.io if you want to have a look at it. What it is, it's an application that sits on the Ethereum blockchain. I am not a part of Kleros. We've been in dialogue, their leadership and I, for the past, coming up to 3 years now, because they essentially, what it is, it's a system where disputes at the moment, mostly very targeted disputes to do with the crypto world, but they certainly intend to scale that up to more mainstream applications. But those disputes are decided by a panel of what they call jurors, who are essentially Tom, Dick, and Harry, and Jane, and Mary, who are blockchain users, and self-select as jurors by staking a certain amount of money on the blockchain. It's as if I paid to be on an arbitration database or list. And so they are randomly selected, and they don't know each other. They're often anonymized, always anonymized, and they decide in consensus. And they are incentivized monetarily to decide in consensus. If you dissent for whatever reason, you are financially penalized. That's an area of applied mathematics called game theory by Thomas Schelling, called this the Schelling point. It is where a group of people who do not know each other, who are not deliberating, who don't speak to each other, try to converge to come to a decision. At the moment, those decisions are very binary. Pay the claimant, don't pay the claimant, list the token, don't list the token. Again, Kleros has received actually as well grants, one of which from the European Commission, to scale that model up to more mainstream commercial disputes, mostly small claims, the stuff that goes under the radar of courts and arbitration that are traditional. And so that, what I find extremely interesting in this model is that it is absolutely aligned with the values of the Web3 economy. The peer-to-peer system is something that's extremely valued online in the blockchain. And actually, if you look at social media, it's not a million miles away of your peers liking a post has a lot more value than if, someone very reputable, but only that one person likes it. And so the fact that you have several jurors, several peers, essentially coming to a decision and resolving your dispute in a matter of hours, and at most a couple of days, completely aligns with the values of what goes on in the blockchain. The very interesting thing for arbitration practitioners, us, is that our future competitors are Tom, Dick, Harry, Mary, and Jane, not lawyers, people who are, users of the blockchain. And it's a lex cryptographica that's developing under our eyes. And I think we have to find out how to remain relevant. And it is not with the process that we know and love that's going to happen. So that, in 2 words, is essentially what Kleros is.
Yeah. Okay. And so, but that means for me, I mean, when I think about, our standard way of selecting arbitrators and the process of how an arbitrator is selected, I mean, all of that goes out the window.
It does.
And we have, like you said, suddenly what your peers like or dislike are becomes much more relevant. But the question for me is, and maybe you can share your thoughts on, I mean, where does due process come into all of this, and the question of trust, like how are you trusting that this is the right way for a dispute to be resolved, or does it not matter because, like Sophie says, the most important thing is that I get my decision within a couple of hours so that I continue working and I don't have the time, patience, or interest to wait 6 months for an emergency arbitrator to decide?
I mean, I think the first point is that there's different amounts in dispute. For instance, Kleros will not, Sophie, correct me if I'm wrong, but it's not going to be sort of $100 million dispute at this point. So those disputes are still going to go to arbitrations. But I think a very important thing that these types of services provide for the users are the resolution of smaller scale disputes where the claimants just don't have, the extra 50,000 they would need to invest in an arbitration in order just to, get by. For instance, in Hong Kong, an emergency arbitrator application is about 35,000 US dollars. So, for instance, if not everybody has the money to spend, even if they have an issue. So I think that's an important service that they provide. In terms of due process, I do think there is a bit of a problem with, being penalized if you don't decide as your other fellow arbitrators, because then obviously the incentive is maybe not necessarily to decide the way that you're, in accordance with your conscience, but in accordance with whatever you feel the throng will go with. I mean, there's a reason why you have dissenting and separate opinions in arbitration. Sometimes they're very valuable, and sometimes, there are massive differences, and those arbitrators don't get penalized for that necessarily. So I do think there could be an issue with that, but at the same time, this is something that is still developing and it is scaling up. So I think we can, have a very educated conversation about this in about, 5 years, where we, all of the problems will have surfaced and, people will try to solve them. But in theory, I think it's a great thing. It, allows more actors to get access to justice, and at the same time, obviously, there can be problems.
I mean, it's worth adding that Kleros is not alone in this space, right? They are the most purist, I would say, the most crypto purists of them all so far. But you have several types of applications, similar applications that take the dispute on chain and send it to a more traditional human. That's the other thing as well. The jurors are human in Kleros. It's important to say that a single human arbitrator in a sort of super fast track system. So that's something that we're more used to, but which is less contained on the blockchain, on the chain.
Yeah. Okay. We actually have some questions in the chat on this, and I'm going to address them to you because it's relevant to what we're talking about now. Seti asks if Claros's framework for is suitable for complex disputes like the Binance arbitration.
The answer to that is no, not in its current incarnation. They are an experimental platform. They exist since, I think, the first white paper was 2017, and they or very shortly before that, and really now are working in earnest, I would say, for the past 3 years, maybe. And so the answer is not yet. It is certainly something that they are scaling up to. Absolutely. I want to say very quickly as well on the question of trust. Vitalik Buterin, the founder of Ethereum, as I mentioned, is a great fan of Kleros, as you might imagine. But he has come up with a new paper on the 10th of May, I think, just earlier this month, where he essentially advocates for a new blockchain ethos that is more reliant on peer approval and reputation. And that is a very interesting climb down from the earlier philosophy of blockchain, where everyone was equal and the thing, you know, didn't matter what reputation was. Everything was decentralized. And I wonder in that if he is going to pursue that idea further, where essentially Bitcoin blockchain users will have this sole token that will be endorsed a little bit like a LinkedIn on steroids, really, by others, by peers, whether that will make a difference in models such as Kleros, where maybe certain jurors will be more trusted and more reputed than others. And then we're entering into something where we are much more comfortable and familiar.
Yeah,
So these things have all considered.
Yeah, like ethics for arbitrators almost, you know, the concept of an ethical approach makes us automatically feel more at home, I guess.
Yes, and I mean, the idea as well of being vetted and, you know, as a decision maker is something that is, again, that brings a degree of comfort, because I think what people find quite destabilizing in blockchain is the fact that the trust is completely misplaced. Instead of having trust in a peer that you don't know and cannot identify, you trust a certain process, or you trust the technology, or you trust the smart contract or the automatization. And now, by putting these cards on the table, Vitalik is essentially saying, wait a minute, this is becoming extremely dehumanizing, extremely financially obsessed. And my problem with Kleros is putting the financial incentivization of jurors at the center of what is a dispute resolution system. I think that's problematic on several grounds, but ethical is one of them. And that would be interesting to see whether Vitalik's proposal, if it is pursued, will be to the table.
Yeah. For me, it's a kind of a sign, because, you know, Bitcoin and blockchain started off as this trustless network, and they had their ideals that it's decentralized and not connected to any government. And now you see, for instance, if, you know, the legacy institutions were here and blockchain was here, it's kind of like, you know, they're going to meet at some point in some way, maybe not completely, but you see that a lot of actors, especially, for instance, after a couple of weeks ago, there was a massive stablecoin crash of Terra Luna. And there you have people, even in the community, asking, should this not be a bit more regulated? Should we not have a bit more, you know, rules in the game? You saw that as well in the sanctions against Russia. You know, crypto companies did enact sanctions adopted by states. So there's going to be some convergence at some point. And even just in the way that, you know, actors in the crypto space are treated, there's now really, really big actors, or really big, as you call them in the community, whales, holders of crypto and other currencies that essentially will be as big as, you know, as big as the millionaires on Wall Street at some point, and will have as much control and influence in the community as before. So I think we're moving away a little bit from the ideals of the community of, you know, let's say 6-7 years ago, and there's going to be some sort of convergence.
We have some more questions on Kleros, and I think they're questions that I would also have asked. Herman is asking if the Kleros decisions are enforceable at law, and whether they're considered arbitral awards. Like if there's already case law of courts having taken decisions on the decisions at Kleros, I guess, if they've been appealed in some way or other, or if, I mean, I think there's so many questions. What is the applicable law? Who are the parties? But yeah, I don't know, whichever.
So the first, with great respect to Herman, these are very valid questions. The first question is meaningless for Kleros. There is no governing law that applies to these disputes. The way in which they are enforced is that the parties stake a certain amount of money in a trust account as they start, and then whomever wins gets the money automatically. So there is no it's all taking place on chain within that ecosystem. So there's no point in taking that decision and taking it off chain. Now, yes, there has been one decision by a Mexican court which did not sort of review a Kleros decision and say, yes, that's valid. What it did is it reviewed an agreement, which was a landlord tenant agreement that had a dispute resolution clause saying if we disagree, we're going to Claros. And the Mexican court decided, yes, that's a valid choice that the parties have made, and we are happy to therefore consider that this decision stands. It did not go back to the decision and decide, is it well decided or not? It did not look at it any further. My understanding is that the Mexican law considers that flipping a coin is also a valid way of dispute resolution. So that's a huge step, I mean, for Claros, because obviously it means that the name is a lot more recognized, and their system is a lot more recognized than it was 3 years ago when I started lecturing about them, and people were looking at me saying, "Oh my God, this is nuts." And now that the Web3 economy has taken off, it makes a lot of sense. Is it enforceable under the New York Convention? I would say absolutely not. The New York Convention is just not set to recognize these types of decisions at all. It doesn't meet a lot of criteria. But at the moment, as I said, unless you need to take that decision off-chain to enforce off-chain, there is not really a need for it to be recognized by the New York Convention. The Claros system provides a means of appeal to bigger and bigger number panels, but that's neither here nor there. Really.
And already people are thinking, people that are listening to you both talking about Claros, they're thinking it sounds like it's much easier to be a juror at Claros than it is to get appointed as an arbitrator.
The only thing
Mohammed is asking, are there certain, sorry, Aija.
Definitely for young practitioners. I do think nowadays
is to stake a certain amount of money. You buy the Claros token, which is called a Pinakian, and you stake it, and then the algorithm, if you stake a sufficient amount of money, definitely you'll be picked. Now, you have to know what you're talking about. I mean, you have to be quite a seasoned blockchain user to be able to decide these disputes. I would be quite at a loss, frankly, myself. But if you are and you are at ease and familiar with that space, yeah, you can definitely. I don't know that you can make a living out of it, but it's a fun thing to do.
I don't think so, but I have some career advice. So if you do these, if you serve as a juror on these Claros dispute resolution platforms, you can absolutely list that in your applications for arbitrator appointments and listings in institutions. I would totally list them. I think for young practitioners, it's really hard to get appointed as arbitrator, just because everybody's sort of, oh, please send us five awards that you drafted in the past year, and the more experience you have, even if it's on-chain arbitration, that's still experience, and I think that could be a good way of getting some extra points if you want to get arbitrator appointments.
I mean, Jur, which is another application that has this more hybrid system, they have specifically a pool of younger arbitrators that you can list for, and so and that they will send some disputes to. It's not the Claros; it's a much more fast track sort of idea, but they are worth scoping out if you're interested in first appointments, for sure.
I think it's a great idea for experience but I mean, I guess it's not, we're talking about young practitioners. I'm sure that anyone who's watching or listening with gray hair can also become
for sure. Yeah, but I mean the question often is asked by young practitioners. Yeah, for sure. Anyone.
Yeah. So Nicholas Pitkowitz, who's actually the vice president of VIAC, is asking whether, so he's kind of going into the legal aspect of it, which I wanted to address anyway. So he's saying, if he understands correctly, the Claros system, the decisions are made by persons who have no legal background and they're not bound by any procedural standards or ethics or law, and whether this defeats the basic understanding, standards of justice and rule of law. And I think and whether a practical, workable fast track arbitration would be viable. But I guess it would need to be, I mean, I'm happy to hear your views. I guess it would need to be very fast track.
I mean, that's something that I've struggled with a lot with in my discussions with Federico Ast, who's the CEO of Claros, because the whole the fairness side of it, and he recognized that this was an Achilles heel. The more I think about this, I think, and of course, in a year's time we can have this conversation, and I'll have maybe another view given that things develop. But at the moment, I think the best proxy, and it would be something akin to baseball arbitration. Really tight deadlines. One proposal by one side, one proposal by the other side, and then the juror decides between those two. And that's it. That to me, and each side has an opportunity to put whatever their case is together very quickly, and then you have abbreviated due process, but certainly equality of arms, and then a decision. That's a known quantity, and it would work, I think.
Yeah, to me, it's also a question of sort of putting limits on parties' consent, because if, you know, in arbitration, whatever the parties want, whatever they consented to wins, to the extent that it doesn't sort of, you know, brush international policy the wrong way and then create problems down the line. Because at the same time, you can have an absolute, you know, you can have an agreement where if you have a dispute with your business partner, you know, his mom and your mom get together and decide, you know, who's right. So it's also a question of how much you can limit the will of the parties. Because at the end of the day, if you agree to it in the contract, contractually, technically, if it's not against, you know, some basic rules of justice, it's enforceable.
Johanna, did you raise your hand? Did you want to ask a question? Or I have a hand raised, so. No, last chance. Well, going on to, because I'm you know, our 40 minutes is very short, especially on a really interesting topic like this. But going forward, I mean, where does that leave us as arbitration practitioners in this world of legal tech? I mean, both from an institutional point of view, but also from an arbitrator's point of view. I mean, where, you know, what kind of skill sets do we need to move forward in this field? I mean, both of you are in, you know, active in the world of blockchain and everything legal tech. But, you know, what advice would you give to anyone wanting to get interested in this field? You know, where do you see institutions going, and where do you see practitioners going? Do we just have to hang up our hats now and say, that's it, you know, the old arbitration world as we know it is, in this field at least, is gone?
I really don't think so. I think alongside, you know, smart contracts and on-chain arbitration, there's going to be classic consumer and contractual arbitration with a bit of legal tech and crypto thrown in. For instance, I've been involved in disputes where one person was supposed to be paid for a consulting contract in crypto. They were not paid. The crypto used to be worthless. 2 years later, it was worth a couple of millions. But because of the fluctuation in the currency, like, how do you ask for, you know, you have questions of how do you ask for compensation? Do you ask for fiat, that is, you know, normal money, or do you ask for the crypto? You can have shareholder agreements where payments have to be made into certain crypto wallets. There, you know, because crypto is going to be, it's both an asset and a method of payment. So there's a lot of issues and just some very classic commercial arbitrations that are going to come up. So I think there's definitely a role to play for, you know, for traditional arbitration institutions. I think it may be helpful to have some sort of addenda to existing rules, maybe sort of a quicker an emergency arbitration type thing. I think definitely a list of experts who are used to, you know, the terms of art and used to how blockchain disputes and blockchain transactions work would be helpful, because obviously if you have, you know, if you want a quick decision, you need somebody who already can orientate themselves in the dispute. And also, you know, just processing things quicker. Maybe the VIAC will start accepting crypto for the initial payment of fees or something like that. That's also a possibility.
Sophie?
I would say I view this space and the Web3 economy as along something that we are going to have to learn to live alongside with or of. It may be a bubble, it may not, but at the moment it's growing. And it is a place where you have very well-established companies and brands appearing. Sotheby's, Christie's, some banks even, for sure law firms will not be far behind. There was the Metaverse Fashion Week a few weeks back with, again, very big fashion brands alongside pure creatures of the Web3 economy. So this is not something that can be ignored if you are going to be serious about engaging with the future of this field. That said, there is a landscape of disputes, and in that landscape, whatever is blockchain dispute resolution is one offering of dispute resolution. There are several. There can be in future very, very simple or repetitive disputes of, I don't know, unpaid licenses that can be resolved by an algorithm automatically and reviewed by a human. There is something like that in Argentina to unclog the courts of Buenos Aires. That's very, very successful. That's one extreme. And then on the right-hand side, you have, I don't know, ISDS disputes that will continue probably for the foreseeable future to be decided in a more traditional way. And then there is in the middle those very commercial disputes that present features that lend themselves very well to blockchain dispute resolution. And they, if arbitration wants to get in on that game, they are going to have to adopt and recognize and adopt the values of the Web3 economy that we talked about: time, immediacy, and the peer system.
Yeah, I would just add that a lot of these crypto companies, for instance, wallet providers, exchanges, also some NFT companies, a lot of them have arbitration clauses, which makes sense. So, for instance, MetaMask and Coinbase have AAA, OpenSea, Kraken, Gemini have JAMS, Binance and Huobi have VICC, and Binance now also has Hong Kong, FTX has ad hoc arbitration. So there, I think it makes total sense for these types of companies to keep those disputes out of the realm of national courts, because imagine a national court judge who's not been trained in this ever, well, most likely, is seeing this for the first time, just going like, what the hell is this? And, and it'll take even longer than arbitration. But it was funny, I attended the Paris Blockchain Week Summit a couple of months ago, and there were no lawyers, well, very few, there were some regulators. And then I talked to some of these guys who are CEOs of these companies about, dispute resolution. They're not focused on that, not really. Their lawyers are a little bit, but they're mostly focused on regulation, how to make sure they have licenses if they need them and they don't get into trouble. But there are going to be disputes coming out of these transactions, whatever they are. For instance, I don't know, you have a MetaMask wallet, and then for some reason somebody steals your NFT out of that wallet, and there's a AAA arbitration clause. There's going to be a lot of very practical issues, I think, for traditional arbitration. It's just that I think in order not to test the patience of the community who want everything now and yesterday, and because I've worked on the Binance case, I've gotten to know a lot of traders who basically, are like, how quick is an arbitration? Like 2 months? Like, no, you have like no idea. It'd be great. But I think we'll have to find some sort of way to cater to our clients, because that's what we are. We are service providers at the end of the day. You as a lawyer, you provide a service. As an arbitration institution, you provide a service. And obviously, you want the people coming to you to be more or less satisfied, because we don't have the luxury of national courts where we can just say, hey, that's just the way it is, and where else are you going to go? So I do think that institutions and lawyers will have to keep that in mind and adapt, which I think is great. The economy is evolving, and so are we.
Yeah, absolutely. I think it's great to have, it's a new challenge, I guess, for arbitration and for arbitrators to kind of embark on this new journey, essentially. I just think it's funny that, we always thought that we're quite efficient especially in big law, you know, that we do these things fast and efficient and we're so service orientated. And little did we know there was actually a next level to it and a whole other community out there that do things faster and more efficiently than we do. But yeah, so I guess it's a learning curve.
One comment on the speed, for instance, for crypto actors, a lot of one of the main reasons why they want and need speed is the volatility of the currency. For instance, Terra Luna that crashed spectacularly a month ago. It was, you know, it went from $40 to $110 and then to $80, and you know, a month later it was down to 25 cents. So all of these currencies are very volatile. So for instance, any amount of time these people spend not trading is basically a loss of opportunity for them. So that's also one of the reasons why they want everything done very quickly. And that's also going to be a challenge for us as practitioners. For instance, if you have that type of arbitration, like what do you do if at the time of, you know, the breach of a contract or whatever the relationship was, your client's loss was $1 billion, and then in the year while you were doing the arbitration, the currency is massively crashed, you know? And that's going to be a challenge for damages experts as well. Like, how do you find the best damages theory and the best approach to valuation when you're asking for compensation or arbitration like that?
Yeah, a lot of open questions and a lot of interesting things to come, I think. I'm conscious of time. So we've basically maxed out our 40 minutes. Maybe it's a little bit too short for a topic like this. But still it's nice to kind of, for anyone who wanted to dip their toe into it, I think interesting to get a first impression of what awaits for the future of arbitration. And it's clear to me, but Sophie and both you and Aija have made it clear to me that for VIAC, it's certainly not an option not to look this issue in the eye. So I'll continue on my mission of setting up a legal task force to address these topics. And I think in the meantime, Sophie, your ArbTech is probably a good address for these issues. And I know I'm going to give you a second to maybe talk about that. You have regular seminars and webinars on these topics, right?
Absolutely. Thank you for allowing me the opportunity to plug it. ArbTech is a discussion group, and we are on Slack. You can also find us on LinkedIn very easily, and Twitter at ArbTech_hub. And we are very much on a mission to make this discussion accessible and understandable by everyone. We pride ourselves in being a fledgling, growing community of not lawyers talking to lawyers, but lawyers talking with entrepreneurs and coders and startups and academics. It is a very multidisciplinary space. We do have these punctual webinars. We had one, for example, on dispute resolution in the metaverse at the end of last year, right the way up to, we had a damages expert actually last month talking about how you value crypto disputes. So all those very open questions, very interesting questions. And if you would like to join us, please reach out. It will be great to have you.
I'm sure now after this webinar, Sophie, you'll have another 70 followers. That's exactly what everyone's going to do when they log off. They're going to go on to LinkedIn and follow ArbTech. So thank you both so much for taking time out of your busy schedules to talk to us. I feel like this is a conversation to be continued. So maybe after we've set up our legal tech think tank, we might do a second session of, we'll do not the ABC, but the DEF of legal tech later in the year. So everyone who's online, please join me in virtually thanking Sophie and Aija, and have a great evening, everyone.
Thank you.
Thank you. Bye-bye.
Ready for attending. Bye-bye.